confirm that we're live. All right, welcome to a very special edition of our Ask the Judge video series, because you hear from me way too often. And so now we're doing a special edition of Behind the Scenes with our Sheboygan County Prosecuting Attorney, Melissa Goodrich, and James Gilbert, who is a public defender both in Sheboygan and in Presque Isle County. And thank you both for taking time out of your busy schedules to join us for this video, where we'll have a chance to answer some questions that viewers have submitted about our roles in the justice system. So first off, do you want to introduce yourselves? Melissa, starting with you.
Melissa Goodrich, I'm Sheboygan County Prosecutor.
And good afternoon, everyone. My name is James Gilbert. I'm one of the public defenders for both Sheboygan and Presque Isle County.
All right. And for purposes of this video, I think for us just to have a free discussion about these topics, I would propose that we've all known each other for a number of years, that we would just refer to each other by our first name. It's not a court appearance. So please, say, hey, Aaron this or Aaron that, and I'll do the same with you both. Does that sound all right?
Okay. Great.
Sure. It's going to be tough.
All right. So the first question I thought we could answer is describe how you view your role in the criminal justice system and share some information about what you do behind the scenes when you're not in court on the record. So Melissa, how about you first?
Okay, I can kind of talk about how a case goes through the system as far as what my role is in that. I receive a police report from law enforcement. I think a lot of times people are confused that we can take action before receiving police reports or just simply take complaints like a 911 call type complaint, but we don't do anything until we receive a police report from law enforcement. And once we review that, we see if that there's enough evidence in order to charge a crime. And once we charge that crime, then we attend a series of court hearings, and a defense counsel is either retained or assigned and go through the case that way. If we deny that there's enough to charge a crime, then sometimes we'll go back to the police officers and ask for further investigation, or we'll contact victims and talk to them about what our decision was and why. For the behind the scenes information, I guess, in between court hearings, or sometimes we're asking for adjournments, is that we're in constant communication with the defense attorneys on how to proceed in the case, how to resolve the case, as well as if a victim is involved. We talk to them every step of the way if they choose to activate their victim rights and get their input too on how the case is proceeding. Sometimes the cases can be fluid, so we're asking for additional discovery, either some more information from the defense as to their clients or their versions of what happened, or from law enforcement.
Okay, thanks. That gives a lot of input. And as you're deciding whether to issue a charge, then are you viewing, whether you believe there's enough for you to secure a conviction at the end of the case, as well as the probable cause standard, or what kind of goes into that thought process?
Correct. Whether there was enough for the arrest, as well as if we go to jury trial, whether we can meet the beyond a reasonable doubt standard at that time as well.
Do you have any sense of, and if I ask a question that's not fair, just go ahead and say so. Do you have any sense of what percentage of cases or number of cases in a year or a month are denied for issuing of charges?
I think that we work with such excellent law enforcement that it would be a small percentage of cases that are denied. Okay,
good. Jim, what about you? How do you view your role in the justice system, and what do you do when you're not in court?
Well, thank you. I was going to say, Your Honor. Like I said, it was going to be tough. And I'm over here taking notes. I felt like I was in the presidential debate there for a minute as I'm writing down things. But as for the public defender's office, we have certain criteria. And at the arraignment, if a person's arraigned right after they're initially charged with an offense, they're asked about whether or not they are going to retain their own attorney, or they're going to be asking for, and we now are called the Office of Assigned Counsel. They're asked that at that time, if they want the office of assigned counsel, then we have to take financial information. The reason for that is that the public defender's office, and we get it all the time when I'm meeting with clients at arraignment, they'll just go, "Oh, this is an easy one. I'll just take the public defender," or I'll just take the public defender on this one. Well, the only people that get the public defender's office are people that are indigent, and there's the probability of jail. So if you receive a ticket that there's going to be no jail time, you're not getting the public defender's office. And if you are not indigent and have a good job, can afford your own attorney, that's what you're supposed to be doing, is hiring your own counsel. So we have to make that determination whether or not it comes through our office. In the area that we're in Sheboygan, there's a lot of people that fall into that category. And so we have a very large caseload. And then one of the 3 public defenders in Sheboygan or 2 in Presque Isle will get assigned to these cases. Now, a lot of times I hear, well, you're a defense counsel, you're just trying to get everybody off. You want to have guilty people all on the streets. It's not that type of situation. You have to remember the defense counsel lives in the community too. We don't want guilty people just roaming the streets. I sort of view a lot of the time, because the majority of the time my clients are guilty, that my job is to try to minimize the penalty that they might be exposed to. So for instance, a lot of times, I'll hear clients say that, well, maybe I should go into one of the treatment courts, a sobriety court or a recovery court. And I have to be frank with them. If you plead guilty to a different charge, you're going to serve this much time in jail. You're not going to do well in a recovery court or a sobriety court. You're not going to succeed. And at the end of the day, your penalty might be a lot larger. So I'm always talking with clients, trying to make sure that we minimize their penalty as much as possible. The other thing is to protect their rights. Melissa made a good point about that. We do have very good law enforcement in this area. And so they do their job very well. But we also have to make sure that the citizens are in the possible defendants, their rights are protected at all times. And that's another big role when we play. And in regards to communication, when we're not in the courtroom, is Melissa and I probably talk as much as anybody does. We text each other. We're on the phone together. We bump into each other in the hallways, always talking about clients, how we're going to resolve cases. There's a great deal of talking back and forth. And a lot of times it's to come up with a resolution that seems fair to everyone, that the victims are protected or are taken care of, their needs are, but at the same time that it's not an over-punishment for the defendant. And so that on a daily basis, those negotiations go on.
Okay. And from my perspective, the things I'm not doing when I'm not in court is, number one, preparing for court. Every time we come into court, each one of us has had to read and review different documents, especially for the sentencings. We talk about the pre-sentence reports. And, I don't know if people understand that for every felony sentencing, at least, there's a written pre-sentence report about the case and about the defendant that's anywhere from 15 to 30 pages long. And you both know about the case, know a lot of those things already, and I know none of it usually. So it takes a lot of time to read all those and get ready for the court. Some of the other time I spend is various administrative duties that we have. There's the office staff that helps out with all sorts of different functions. There's the state court administrator's office and the Michigan Supreme Court come out with different rules of procedure. We work with the clerk's office and with different attorneys and with the probation officers to change some of the systems of how we do things. So those administrative duties take a great deal of time as well. And then just as we all do, staying up on the law, that takes time to read the cases and go to trainings and that. And my role is really to be as neutral as I can. Humans are humans. And so people, have opinions. But, the role of a judge in the system is to, as much as humanly possible, set those things aside and decide the case fairly to both sides. And I will say that, when the cases come in front of me, my primary concern is whether the process is fair and everybody understands what's going on. I really try to keep out of my mind, whether I want one side to win or not. That's not important to me at all. There were some interesting questions that came in about us and how we deal with the cases kind of personally. So how do you remind yourself to stay grounded and not become overwhelmed or overly emotional during tough cases? Any input about that?
You want to go first this time?
I can. The thing is, you do get emotionally attached to certain cases. And, there's ones that have come through our circuit court in the last month or so that I've had experiences with it, not acting as the defense attorney, but acting in different capacities for other courts that I was involved with the case in one way or another. And you do get emotional. How you keep grounded? I guess it's just that after a matter of time, you get used to it. And so I guess in general is that you're not always grounded. No one is. Sometimes you do get emotionally attached in cases. However, I think over time you learn to, your skin gets a little bit thicker and you don't get as attached that often. I guess that would be a good way to sum it up.
Yeah, I think that's fair too. And for all three of us, we've been involved in the criminal justice system a long time. And I find if I'm at family functions or social functions, and I'm just talking about work in general and start telling some story about an old case, I'll say something that I think is perfectly normal. And then all of a sudden I see the horrified looks on the people around the table. And I realize, oh my goodness, I forgot that I've got a thicker skin about this because I deal with it so often. And sometimes what we deal with is pretty shocking. But, I think during a case, what helps me is, and I think this is only for my role, is trying to consider all sides. So whenever I feel myself start to get emotionally pulled in a case, I mentally step back and remember that I have to consider all sides. So I'm not just considering the impact of the case on the crime victim, because that can be very emotional sometimes. But then I have to stop back in my role and also think about what is the impact of this sentence on that defendant and on the defendant's family. And that sometimes is quite emotional as well. And so I have to step back and consider all those, and also then the larger community as a whole. But in general, I think what helps me is just having some positive connections with other people outside of the court system, and finding out, for each lawyer, what recharges you, what refreshes you, what relaxes you, and doing those things, because I think you're right, Jim, that to say we're always grounded about it is just not right. I mean, that there are plenty of times where I've had to step off the bench and close my door and take a few minutes to compose myself after a case, because it's pretty tough. And Melissa, I'd be really interested in your perspective, because in your chair, you have to talk directly with victims of crime much more than either Jim or I do, and how you manage some of the stress and emotion of that.
Yeah, and I think keep reminding yourself that you're in the courtroom and supposed to be the unemotional voice trying to handle a case. And also kind of, as you talked about, the respect of everybody in the courtroom, that you stay unemotional during the hearings, because everybody has their own viewpoint about what is going on. I think what has surprised me as prosecutor is even when it's well-deserved and someone's going to prison, how difficult that is and how that never gets easier, because you realize the ramifications on not only that person's life, but their families and everything that's involved in that, that has not become any easier. But certainly there's rewarding moments too, when a victim feels like they were heard and believed, and going through that with them makes the job so wonderful. But also rooting for the defendants at times, such as in our recovery court program, when we get to see somebody who has an addiction and they were able to treat the addiction and become better citizens in our community. And I think that people assume prosecutors are just sitting there rooting against the other side, but I love that scenario when we actually get to help.
Yeah, that's a great point too. And I think that that's super helpful for our participants to have you on the team. Here was another kind of personal question. What's your least favorite task to do in your day-to-day job duties, and why is it your least favorite?
That one's easy for me. My least favorite is when I have to prepare a child to testify at trial and go through their story, because from what I've read, that it's just as traumatic as the first time that it's happened to them. So that is easily the least favorite part of my job, because I feel like I'm contributing, I'm actually causing some harm to them by preparing them for that trial, even though it's necessary.
Wow. Okay. For me, I think that the least favorite task that I have is the times when I have to impose a sentence that is like decades long, and that I know is just a life-changing sentence for that person. Even, I only give those sentences when I believe that the law and justice requires it. And so I understand that it's a good thing for that sentence to be pronounced, but it's a hard thing to do, and it never brings me any personal satisfaction, because it just weighs heavily that's a human being, and I just ordered them locked up basically for the rest of their lives, or for decades of time, and that's my least favorite thing to do.
See, and I read that question a little bit different. I was looking on a daily basis. So what I was thinking, my worst thing on a daily basis, the two of you have this very profound thing that happens occasionally, but mine was chasing people down daily. Every day I hear this person's not accepting telephone calls and their voicemail's full. Drives me insane.
Okay. Well, there you go. Yeah, that's good. Yep. So growing up in school, middle school, high school, did either of you have your mindset on criminal justice, or did that happen later in life?
Am I going first this time, Melissa?
Sure.
Well, my father was an attorney, so that probably already had it set in my mind. I've always been the legal. I grew up in a legal family. The joke was, though, I was the only one that did not work in my dad's office as some sort of intern. My two sisters had, and I'm the only one that was dumb enough to become an attorney. So they knew what they were getting themselves into and didn't do it. So I think mine was probably mostly motivated by following in my father's footsteps.
Okay. Melissa, did you always want to be a lawyer or be involved in criminal justice growing up?
So surprisingly, in 5th grade, I decided that I wanted to be a lawyer, but then it took 3 schools and 4 majors to end up doing what I started doing. So there was other things considered.
Yeah, that's similar to my story. When I was a little kid, I wanted to be a lawyer. Some of that may be my uncle, Joe Kukuski, who just passed away, was the Sheboygan County prosecutor. And I grew up just looking up to him, and he was my hero. And I loved following after him in some of those cases. And he let me be his gopher for a couple cases in high school, a murder case even. And I just fell in love with the law by watching his passion for it. And it's something I always wanted to do. But I did get sidetracked and did some other majors and some other jobs before I got around to it. But I'm really glad I did. Any advice for someone who is young and would want to work in the court system as a lawyer, or even a court reporter or clerk or police officer, or involved in the legal system in any way? Any advice?
My advice is to call whatever office that you're interested in doing and asking if you can job shadow, whether it's for a day or a semester. I know in the prosecutor's office, we always try to pay it forward, and we've had college students who want to be lawyers sometimes just visit us for the day and come see a circuit court docket and watch it. And we talk to them about it before the docket happens and then have them sit through it. Right now we have a senior high school intern that's interested in going to law school, that is viewing a lot of courts and interested in our office and comes daily for that. We also plan to have a law school intern next summer spend 12 weeks with us and get experience in the courtrooms. So I think whether it's you want to be a lawyer or a court reporter to just be able to follow that person around and see what they actually do, I think most people would be surprised how many other jobs there are other than just the judges and lawyers.
Okay, good. Anything to add to that, Jim?
I was going to echo the exact same thing. If somebody's interested in this occupation, you definitely should do an internship and or shadow, like Melissa talked about. Because to be honest, after I passed the bar and started practicing law, I didn't like it. I did not like general practice. I didn't like doing divorces. I didn't like doing real estate. There was a lot of things about the practice of law I just thought was boring. And now, at the time, it sounded great while I was in law school, but then when the practicality came, I didn't care for it. And the same thing is, we talked about our other professions. Before going to law school, I was a CPA. And while you're doing it in school, yeah, the numbers and all that, it's fun solving the equation, but the actual practice was something I didn't care for. But there are different aspects to the legal profession. I have a job now that I absolutely love. I enjoy going to work, but on the other hand, it is not for everyone. It's very stressful and it's anxiety ridden. And as we talked before, sometimes we're just not grounded and it is emotional, but I would really investigate where in the judicial system or any job opportunity before diving, feet first into it.
Okay, good advice. We had a couple of questions about criminal procedure. One of them, the more general one, is why do some cases seem to take such a very long time to get through the court system? Any insight into that? I mean, one of the things right off the top of my head, the people that are viewing this, everything that nothing was on YouTube before COVID, and so probably 66%, 2/3 of the reasons for the delays have been COVID related almost directly. So people watching it are seeing cases take longer to get through the court system than is typically the case. There are time guidelines that the state gives us that have been sort of waived for now, but outside of the time of COVID and once we're through the backlog, just as an example, in criminal cases, we're supposed to have 70% of felonies resolved within 90 days of the bindover. And we're supposed to have 98% of them resolved within a year. And so, we've got some time guidelines to follow, but COVID's rendered them impossible. Because if people wanted a trial, we had to, delay that for quite a while. Any other perspective that you guys have on why do some cases seem to take so long?
Well, I think you hit it right on the head. COVID has delayed things a lot, and and we all know that we had no trials for almost a year, and so those cases have delayed much longer than they would have before COVID, or then hope to delay after COVID in the near future.
Okay,
I would agree. It takes time, and then when you're wanting to meet with people or coordinate with people, everything is just taking a little longer right now.
Yes, and even aside from that, sometimes, and it's important for people to remember when they watch some of these things. If you watch long enough, you're going to see all three of us on this screen right now be irritated with each other at some point about some case. I'll be irritated at Jim. He'll be irritated at me. He'll be irritated at Melissa, vice versa. All of that, because there's so many things happening, and three human beings have three different perspectives on those cases from time to time. But despite any of those things you might see, it's recognizing that any delay in a case is almost always then because if it's not COVID, you guys can't just decide on the spot, here's what should happen in this case. You both have folks you have to talk to. You've got victims or police officers to talk to, or the defense attorney has the defendant's family. Maybe the defendant's incarcerated and he needs to communicate with his family about a plea before he decides to take it. Maybe you need to check with a witness or follow up a lead to see if there's a viable defense, so all of those things. So that has to always be remembered too.
And then all those people are dealing with their own COVID emergencies or restrictions with their own families and so forth. So it compounds that way.
Yeah, that's true. That's true. We got a detailed question about forensic exams. That's the psychiatric exam for whether someone's competent. At the arraignments, I always ask the defense attorney whether a forensic exam is requested. And somebody asked, well, does the prosecutor get any say about that?
We do. It can be by a motion. Unfortunately, we really don't have any direct contact with the defendant, only in a court setting when they're sitting next to their attorney. So I usually rely on the defense attorney's perspective on that because they're the ones dealing directly and having conversations and spending a lot of time with the defendant.
Yeah, and the court can even enter that. So the law does allow any of us to request that at any time, not just the arraignment. But I asked the defense attorney at the arraignment for exactly the reason you said, Melissa, that they're the ones that have the most direct contact with the defendant and might know if there's an issue that we need to look at there. But at any time during the case, if any of the parties think that issue is that there's a mental health issue, that can be raised. And I have seen that raised by a prosecutor, I think once in the last year. I forget if it was you or Mr. Radzban and Presqu'île, but that can happen. Question about sentencing. When we say that's a 5-year felony, what does that mean? Is it the minimum or maximum? That's an easy answer. It means the maximum. It doesn't mean that that's what they're going to get. That's the maximum they could get. And the reason you hear me say that all the time is because we have to advise the defendant what the maximum penalty is before they would enter any plea so that it's voluntary. They know all the facts. But this I thought was an interesting question. Do comments by the defense, or I guess by the prosecution as well, do they affect the outcome at sentencing? So at sentencing, when you both say things, I guess what goes into your decisions about what to say, and do you think that it matters?
I know I read through the pre-sentence investigation. I also talk to victims before the sentencing, but also the day of sentencing, I do listen to what the defense attorney and the defendant have to say. And sometimes that does impact what I have to say, whether it's important to me if they are holding themselves accountable to what they've pled to, or if they're doing any type of victim blaming, that's certainly upsetting. So that can vary what I have planned to say that day.
Okay.
Well, and I guess when I'm allocuting for a client at the sentencing, I'm thinking mostly of what will put my client in the best light to the judge. And that's what I try to bring out so the judge sees those positives. A lot of times, maybe the client's been very proactive. Maybe everybody makes mistakes. Defendants aren't all bad people. There are some. However, people make mistakes, and sometimes you have a client that's very proactive out doing community service. They identify that they have an abuse problem. They're already in AA. They're already seeking counseling. That's a lot of things that I think the judge needs to know. And I absolutely believe what I have to say affects the judge's opinion. I can count on numerous occasions where we've had a PSI, a report that gives a recommendation to Judge Gauthier or any of the judges that I practice in front of. And after I'm done talking, the judge does something completely different than the recommendation. And it's obvious that it was based off of what either I said or what Melissa said.
Yeah, and I can say I prepare for sentencing by reviewing that pre-sentence report, reviewing the file, and I prepare a single-page worksheet of my own that has various factors that I think are the most important to me. And then it culminates with some notes to myself about what my anticipated sentence is before I come out. And so I've got that written down in 98% of the cases. Sometimes it's so strange, I've just got a big question mark by that, and I wait and see what happens that day. But most of the time I have it written down what I think I'm going to sentence. But many times, the sentence that I pronounce is not the sentence that I wrote down as notes to myself, based upon what the attorneys or the victim or the defendant has said at sentencing. The victim impact statements are sometimes quite powerful because they bring some of the details of the case that didn't come through in the police reports or in the pre-sentence report. So that's a real helpful thing. And hearing, I think that's the hardest decision for a defense attorney. Like, how do you decide whether to recommend for your client to say anything or not? I can tell you, I never hold it against a defendant when they don't speak. But sometimes when they do speak, they hurt themselves, that's for sure. But other times when they speak, they really help themselves. So how do you as a defense attorney judge whether you want to recommend to them to say anything?
Well, as we were talking here, and I'll go back to another question. What's the worst part of our job is, especially during a sentencing, when the victims are talking, standing up, and especially with a child victim or that type of thing, standing next to the defendant that done something poorly to that victim. That's probably one of the worst parts of my job, other than the telephone calls I mentioned earlier. But you sort of, when you're talking with your clients, there's a lot of times I say, I really don't, you have a right to remain silent. I think we need to use it because I know you talking is going to get you farther in.
All right, let's talk about that. This wasn't a fiery, dramatic hearing, but more of a sit down with the people who actually keep the courtroom running day in and day out. Judge Aaron J. Gauthier steered the conversation with his trademark composure, calm, clear, and refreshingly candid about the less glamorous parts of the job. He didn't posture or grandstand. Instead, he gave thoughtful answers about fairness, preparation, and the human side of sentencing. You could sense his focus on process over outcome, which is exactly what you'd want from a judge. What stood out was his willingness to admit the hard parts, like having to impose long sentences and the emotional weight that carries. Not every judge would pull back the curtain like that, and it gave the whole discussion a more authentic feel. On the prosecution side, Melissa Goodrich was steady and professional, walking through how cases actually move from a police report to a charge. She didn't oversell her role, which I appreciated. No. Tough on defendants. Talk. Just a straightforward explanation of why prosecutors sometimes have to say no when there's not enough evidence. She also gave some very real insight into the challenges of dealing directly with victims, particularly kids. That honesty about the emotional toll was powerful without ever tipping into drama. She came across as someone who genuinely tries to balance seeking accountability with compassion for everyone involved. Then we had James Gilbert, the defense attorney, who clearly enjoys injecting a bit of humor into serious topics. He joked about feeling like he was in a debate while scribbling notes, but then pivoted to some very practical insight into what defense work actually is: protecting rights, negotiating fair outcomes, and yes, managing a large caseload. His candor about the fact that most of his clients are guilty of something, and that his role is often about minimizing the penalty rather than securing some magical acquittal, felt refreshingly honest. I also liked that he acknowledged the community aspect. Defense lawyers live there too, so it's not about getting everyone off, but about ensuring justice is proportional. The overall tone of the discussion was collaborative rather than combative, which is unusual if you're used to watching actual adversarial hearings. These three made it clear that, outside the heat of the courtroom, they talk constantly, negotiate, and often agree on what's fair. That's not something the average viewer might realize, but it explains why many cases resolve without trial. There were also some light, human moments. Gilbert poking fun at chasing down unresponsive clients, or Judge Gauthier admitting that sometimes he has to close his door and take a breather after an emotional case. Those details painted a picture of a justice system run by real people, with all the stress and fatigue that comes with it. What really came through, though, was the balance between the law as procedure and the law as a human experience. The judge stressed neutrality and fairness. The prosecutor highlighted both accountability and empathy. The defense lawyer underscored rights and realistic outcomes. Together, they gave a behind-the-scenes view that was respectful, informative, and, at times, surprisingly relatable. It wasn't a circus, it wasn't tense. It was professionals talking about how they keep the wheels of justice turning, even when the job is tough. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.